Hello Year 12s and welcome to this video on the separation of powers. There are 4 things that you need to do while you're watching this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go over any information contained in this video. The third thing you need to do is have your vocabulary sheets open in front of you so that you can write into your vocabulary sheets the definitions of key terms or of any other words the meaning of which you're unfamiliar with. And the fourth thing that you need to do is have your summary books open in front of you. As we go through this video, I will give you some guidance as to what you should write in your summary books. When you've finished watching this video, make sure that you read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. On this slide, I've set out the learning intention for this video. Make sure that you write this learning intention down in your Cornell notes. As a result of watching and taking notes on this video, you should be able to describe and explain the reasons for the separation of legislative, executive, and judicial powers. The principle of the separation of powers requires the 3 different types of power in our parliamentary system to be held and exercised by different bodies, so that no one body has absolute power and control over the functions of the political and legal systems. In the next slide, we'll look at what these 3 different types of powers are and the bodies that exercise these 3 different types of powers. But the important point for the moment is that because of the principle of the separation of powers, no one body has absolute power and control over both the political system, that is Parliament and government, and the legal system, that is the courts. Look down the left-hand side of your vocabulary sheets, find the term separation of powers and write this definition in there. Once you've done that, highlight the words in red bold italicized type. And if you're ever required to describe the separation of powers, make sure that you include the highlighted words in your description. The principle of the separation of powers is a really important principle which underpins our democracy. By ensuring that no one body has absolute power and control over both the political and legal systems, this principle prevents there being a dictatorship. In a dictatorship, one person, the dictator, controls the government, the parliament, and the courts. As we'll see in a later video, the principle of the separation of powers is entrenched in the Australian Constitution. But this constitutional requirement for the separation of powers only applies at the Commonwealth level. That is, the principle of the separation of powers only applies to the Commonwealth Parliament, the Commonwealth Government, and the Commonwealth or federal courts such as the High Court. Conversely, this constitutional requirement for the separation of powers does not apply at the state level. That is, it doesn't apply to the state parliaments, the state governments, and the state courts. As I've said, there are 3 different types of powers, and each of these types of powers is exercised by a different body. The first type of power is legislative power. Legislative power is the power to make laws. This power is exercised by the Commonwealth Parliament. The second type of power is executive power. Executive power is the power to administer the laws and manage the business of government. This power is exercised by the Governor-General as the Crown's representative at the Commonwealth level on the advice of the ministers, that is, on the advice of the Commonwealth Government. This is really a polite way of saying that the Governor-General exercises the executive power as required by the Commonwealth Government. And the third type of power is judicial power. Judicial power is the power to enforce the law and determine disputes. This power is exercised by the High Court and other federal courts. Look down the left-hand side of your vocabulary sheets and find the terms legislative power, executive power, and judicial power. Then write into your vocabulary sheets the definitions of each of these powers, together with the body that exercises each of these powers. Now, even though we say that there's a separation of legislative and executive power, this is not a strict separation. Put another way, there's an overlap between legislative and executive power in that, in some circumstances, the same body exercises both legislative and executive power. Specifically, there are some circumstances in which the government, that is the executive, exercises legislative power. That is, there are some circumstances in which the government is involved in lawmaking. However, despite this overlap, there are safeguards that are built into the Australian parliamentary system that are intended to minimise the risk of the government abusing this lawmaking power. On the left-hand side of this table, I'll set out the circumstances in which the government is involved in lawmaking. And on the right-hand side of this table, I'll explain the safeguards that are built into the Australian parliamentary system to minimise the risk of the government abusing this lawmaking power. Make sure that you include this table in your summary books. The first situation in which the government is involved in lawmaking arises from the fact that under Section 64 of the Constitution, ministers in the Commonwealth Government must be members of the Commonwealth Parliament. That is, a person can't be appointed as a minister unless they have also been elected as a member of the Commonwealth Parliament. This is an important part of the principle of responsible government, which means that ministers are accountable to Parliament for their actions, in the sense that, because ministers are members of Parliament, Parliament can question them about what they are doing as ministers. This questioning can occur during question time, or through the minister being required to attend before a parliamentary committee that can then ask the minister questions about the department that the minister is in charge of administering. The important point, though, is that because ministers are part of Parliament, then not only do they exercise executive power because they're part of the government, but they also exercise legislative power, because as members of Parliament, they vote on bills that are being considered by Parliament. That is, they participate in lawmaking by Parliament. The second situation in which the government is involved in lawmaking is that for a bill that has been passed by the Commonwealth Parliament to come into operation as a law, the Governor-General must give royal assent to that bill. Giving royal assent is part of legislative power because it is a stage in the making of a law that has been passed by Parliament. Yet, as we've seen, the Governor-General exercises executive power. And indeed, in practice, the Governor-General acts on the advice of the government in giving royal assent to a bill. That is, in practice, the Governor-General gives royal assent to a bill when the government requires the Governor-General to give that assent. So here again, we have the government, in this case the Governor-General, exercising legislative power. And the third situation in which the government is involved in lawmaking is where the Governor-General, acting on the advice of the government, makes regulations. Regulations are sometimes referred to as subordinate legislation. Regulations are a kind of law. Often what happens when Parliament passes an Act is that the Act doesn't deal with all of the matters that need to be dealt with. So the Act will say that the Governor-General can make regulations, that is, rules, about matters that are necessary for the proper operation of the Act. In this case, what is happening is that, through the Act, Parliament is delegating or giving its lawmaking power to the Governor-General so that the Governor-General can make rules about those matters. Now, of course, the Governor-General doesn't make up the regulations by him or herself. The regulations are actually drafted and approved by the ministers. And then the Governor-General, acting on the advice of the ministers, will sign those regulations into law. So here again, we have the government, in this case the Governor-General acting on the advice of the ministers, exercising legislative power. However, there are safeguards built into the Australian parliamentary system to control these exercises of lawmaking power by the government. First, even though ministers are members of Parliament, it is only Parliament that can make legislation. That is, it is only Parliament that can pass an act or statute. The ministers, as the government, cannot by themselves make legislation. As you know, there are other members of Parliament besides the ministers. These include government backbenchers, the opposition and the crossbenchers, and Parliament can't pass a law unless a majority of members of both the House of Representatives and the Senate vote in favour of that law. Second, as I've explained, the reason for ministers being members of Parliament is so that they can be held accountable to Parliament. This means that the ministers can be questioned in Parliament about what they're doing. These questions can be asked in question time or through the minister being required to attend before a parliamentary committee. This is an important part of the principle of responsible government under which ministers are accountable to Parliament for their actions. This means that, among other things, a member of Parliament could question a minister about regulations, that is laws, made by the minister. In this way, Parliament is able to hold the minister accountable for the minister's actions in making those regulations. And third and finally, even though ministers can effectively make laws in the form of regulations or subordinate legislation, the scope of these regulations, that is, the matters that can be covered by these regulations, is set out by Parliament in the Act that authorises the regulations to be made. In addition, if either House of Parliament disagrees with the regulations that are made, then within a certain time after those regulations are made, that House can revoke, that is, overturn those regulations. In this way, Parliament is able to exercise some control over the minister when the minister is making laws in the form of regulations. In contrast to legislative and executive power, where there is not a strict separation between them, there is no overlap between judicial power on the one hand and legislative or executive power on the other hand. Instead, there is a strict separation of judicial power from legislative and executive power. Put another way, under the Australian Constitution, where a Commonwealth body exercises judicial power, it is prohibited from exercising legislative or executive power. And where a Commonwealth body exercises legislative or executive power, it is prohibited from exercising judicial power. This is a very important principle, so make sure that you include a summary of this slide and of the next slide in your summary books. This strict separation of judicial power from legislative and executive power is demonstrated in three ways. First, only a court can decide if a person has contravened, that is, broken, a law. Parliament makes the laws, the government, that is, the executive, administers the laws, but it is only the courts that can decide whether a person has broken a law. Neither the Parliament nor the government can find a person guilty of breaching a criminal law or liable for breaching a civil law. Instead, it is only the courts, that is a judge and, where applicable, a jury, that can decide whether an accused is guilty in a criminal case or whether a defendant is liable in a civil case. Second, while the courts do make law in the form of common law or precedents, they only do this as part of exercising their judicial power to decide a case. The primary role of the courts is not to make laws, but to decide cases. That is, to resolve disputes by deciding whether a person has broken a criminal law or a civil law. Therefore, even though the courts do make law, they only make law in a very limited way. A judge just can't wake up one morning and decide to make a law about negligence. Instead, the judge has to wait until a case comes to the court that raises an issue of negligence before the judge can make a law about negligence. And finally, the courts are independent of political influence. This means that the courts are independent of the Parliament that makes the laws and the government, that is the executive, that administers the laws. Let's look at this last point in a little more detail. The independence of the courts from Parliament and the government is a very important concept because we need courts to protect us from a misuse of power by Parliament or the government. So, for example, if Parliament passes a law that breaches the Constitution, it's important that the courts are independent of Parliament so that they can declare that law to be invalid. If the courts weren't independent of Parliament but were controlled by Parliament, then you wouldn't get a fair decision because the courts would presumably declare the law to be valid. Similarly, if the government does something that breaches a law, we need courts that are independent of the government because it's only then that the courts will be free to declare that the government has breached the law. So the independence of the courts from Parliament and the government is really important to protect us as citizens from any misuse of power by the Parliament or by the government. Now, if we look at the High Court, it is the case that High Court judges are appointed by the government, that is, by the executive. However, there are a number of ways in which the Constitution, specifically Section 72 of the Constitution, protects the independence of the High Court judges from Parliament and the government. First, a High Court judge can only be removed, that is, sacked, from their position on the High Court if both the House of Representatives and the Senate vote to remove that judge from their position on the High Court, and if the judge has either misbehaved or is incapacitated. That is, something's happened to the judge which means that the judge can no longer properly perform their role as a High Court judge. So, neither Parliament nor the government can simply sack a High Court judge because they disagree with that judge's decisions. Second, a High Court judge's remuneration, that is the amount of money they're paid, can't be reduced while they're in their position as a High Court judge. As of 2020, High Court judges are paid somewhere between $550,000 and $600,000 per year. So, if a High Court judge was appointed to the High Court on a remuneration of $550,000 per year, then that remuneration cannot be reduced below that level for so long as they are a High Court judge. It's a wonderful job, isn't it? It's probably the only job in Australia where your salary can go up but not down. However, the reason for this is to stop Parliament or the government from influencing High Court judges by being able to punish them for decisions that Parliament or the government disagrees with by reducing their remuneration. And finally, a High Court judge is entitled to continue in their role as a High Court judge until they turn 70, or until they resign earlier if that's what they want to do. Once the High Court judge turns 70, they must resign. So you can see that the Constitution goes to some length to ensure that High Court judges are independent of both Parliament and the government by giving High Court judges a very secure job. Once appointed to the High Court, a High Court judge is entitled to stay in that position until they turn 70. And while they're in that position, their remuneration can't be reduced. The only way in which a High Court judge can be removed from their position is if both Houses of Parliament vote to remove the judge, and then only if the judge has misbehaved or is incapacitated. This means that when the High Court hears a case that challenges the validity of a law that has been passed by Parliament, or when the High Court hears a case where one of the parties to that case is the government, then the High Court judges are not under the influence of either Parliament or the government. That means that they'll be able to make a fair decision, that is a decision that applies the law and that is not improperly influenced by either Parliament or the government. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to describe and explain the reasons for the separation of legislative, executive, and judicial powers. Don't forget to read the pages from the textbook referred to on the first slide in this video. And if you find any additional information from that reading which you think is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.